There's a point at which the might of authority, once thought unshakable, caves under the weight of its own pride. For over 2 decades, Clark County Sheriff Jamie Knoll rose through the ranks with confidence and assuredness. One who believed himself to be the embodiment of a man above the reach of criticism. To him, the badge was a symbol of law and order, and, to a much greater extent, a shield against accountability. For he was the law, or so he considered himself. But in June 2023, the foundation of that belief began to crack, and what followed was a slow, relentless collapse.
State order, 12-8-87. Thank you, Howell, 52, sir. And the last four digits of your social security number? Special prosecutor Furlong has charged you with 15 counts of criminal conduct. I'm going to do count 1. Corrupt business influence is a level 5 felony. It would indicate that pursuant to Indiana Code 35-44-1.1-2-1, that on or about a period of time from November the 9th, 2018 and August 16, 2023 in Clark County, state of Indiana, you did knowingly or intentionally through a pattern of racketeering activity acquire or maintain, either directly or indirectly, an interest in or control of property or an enterprise contrary to the form of statute in such case may provide. Count 2, theft as a level 5 felony. You then personally sold held at for $83,000, $83,716. Count 4, theft is a level 6 under Indiana Code 35-43-4.
The Indiana State Police had been stirred into action by some disturbing signs of misconduct on Knoll's part. What they dug up was far worse than anyone in Indiana had imagined. A staggering theft of over $5 million in taxpayer funds. For someone who had been committed to public service, it was no mere slip-up, but the wholesale betrayal of the very people placed their trust in him. His discovery led to an immediate removal from office, but that was only the beginning. The charges kept multiplying as the investigation continued. Months of scandals appeared to fall like this during this period, each one opening an even more deep and systemic rot. But the judicious prosecutors wanted to present a case so detailed that all could see the writing on the wall, as well as how it reached his coffers. Knoll had used embezzlement, but also patterned racketeering, by which he seemed to have acquired property he controlled in illegal ways. Indeed, so brilliant was this scheme that it managed to avoid detection almost for 5 years, from the last quarter of 2018 to mid-2023. It said much about Knoll's temerity as much as his self-confidence to ever pull such a scheme off without one stumbling upon it. But specifics didn't end there. Financial fraud was only part of the scheme. There was the stealing of a Hellcat, a $83,000 high-performance car Knoll had sold. But the brazen act barely began to scratch the surface of greater crimes. Even as he stood before the judge, even more of his deception found its way into the light of day. Knoll had corrupted even the every nook and corner of his position and duty as sheriff. When investigators arrived at his property, he had desperately tried to smoothen away the evidence of his crimes by resetting his phone in an effort to cover his tracks. It was an act too clear. There was a man who had come to think that he was above the law and that he could well cover up his misdeeds with the same impunity which has allowed him to fester in so long. But Knoll only extended as far as extortion of money, power, and material goods. His abuse of authority, however, was as general as were the people he held sway over. Instead of serving the public, employees were entrusted to do personal things for the sheriff. They worked on his private properties, his rental homes, even on the land owned by his father-in-law, all in the name of service to the public. In reality, the sheriff had a long time ago lost interest in serving the people for self-serving purposes. The list of offenses seemed to grow each day, and one of the most damning charges made against him was official misconduct, a betrayal of his sworn duties as a public servant. For 4 years, Noel had indulged himself in ghost employment, paying people for work not done. His actions were steeped in deceit, a man who had forgotten long ago what it meant to keep the law. As the case built against him, the penalties loomed into view. The most serious charges, level 5 felonies, could snatch away his freedom for up to 6 years. Even the lesser counts, level 6 felonies, could bring more than 2 years behind bars. Financial penalties alone could run into tens of thousands of dollars. A fine and/or prison sentence was the least of it.
On or about August 16th, 2023, in Clark County, the state of Indiana, you did knowingly or intentionally alter, damage, or remove any record, document, or thing with the intent of preventing it from being used, produced as evidence in any official proceeding or investigation. That being, you factory reset your phone upon the arrival of the Indiana State Police on your property. You, in your capacity as Clark County Sheriff and public servant, did knowingly or intentionally assign to Rodney Walker, an employee under your supervision, duties that were not related to the operation of the governmental agencies that you serve. That being, sheriff assigned Walker duties on your personal property, rental property, father-in-law property, pole barn, property due to the fire department. Count 11 and count 15. Official misconduct of 6 felonies within a count. 2018 and December 31st, 2022 in Clark County, state of Indiana. You, public servant, that being Sheriff, Clark County, knowingly or intentionally committed an offense in the performance of your official duties, that being ghost employment as Sheriff of Clark County relating to red fishing. Mr. Knoll, the first 3 counts are level 5 felonies, which have a range of imprisonment from 1 year to 6 years, with the advisory sentence being 3 years and up to a $10,000 fine. Counts 4 through 15 are all level 6 felonies, which have a range of imprisonment of no time in jail, treated as a misdemeanor, to 2.5 years in the Indiana Department of Corrections, with the advisory sentence being 1 year up to a $10,000 fine. Do you understand what you've been charged with? Yes, Your Honor. Do you understand the potential penalties? Yes, Your Honor. The next one, usually if you intend to hire a lawyer, always have counsel seated. I need to tell you, you have a right to a speedy public trial by jury in this county. You have the right to face all witnesses against you, severe question and cross-examination.
The disgraced Sheriff Jamie Knoll, who sat in an electrified courtroom seemingly so calm as he listened to the judge carefully count out 15 charges. With the enormity of his crimes laid bare, in some way, it was as though Knoll still clung to an illusion that his position and influence might protect him from being dealt full force with the law. But the system was now closing in, and each word of the bench chipped away at his illusions of control. Ardent against letting Knoll receive bail, the attorney finally argued he went through with his victories on the severity of the crimes presented before the court. The entire room could sense that the previous sheriff had shaken the very core of trust within the community, and that, yet, to everyone's astonishment, he upped the ante by allowing Knoll some temporary freedom. Bail was granted under strict conditions: $75,000 in cash, the surrender of all but one firearm for personal protection, and an order that Knoll not leave Indiana without court permission. The sheriff was to return his passport the next day and surrender himself by the following Monday.
Passport with you by noon tomorrow, and then you will surrender it to the court by 4 p.m. next Monday, because it's my understanding the court here is closed tomorrow. Yes, sir. He will surrender all firearms except one shotgun of his choice, Indiana State Police. Be it from the country or officer in Washington County. I keep my shotgun double lock near me, along with my 45, but I think one shotgun for personal protection is appropriate for him to maintain. It will not leave the state of Indiana without permission from the court of $75,000 in cash. Mr. Nolan, he wanted to be released without posting any bond, but it's an unique case, and if you don't like my decision, I'm happy for you to appeal it. It won't be the first time you've appealed me, and the Court of Appeals told you I was right, so I'm happy to accept that challenge, so please, I'm not going to...
However, even in this conciliatory move, the foreboding was there. Though he granted his ruling, he did not make room for leniency if one breaks the stipulations. Such a warning stands clearly. One shotgun for defense, no more. If deceived or gets tough, it would be very hard.
Keep one shotgun open. Try to deceive me will not like the consequences. Understand?
Can the judge issue return of all of the items taken in another hearing?
What's that for today?
Got it.
Yeah, we'll deal with that at another time. I think now that everything can be unsealed, there'll be a lot of new things brought before the court.
Yes, sir.
We'll address in due time.
Thank you, Judge.
Anything else?
Nothing else from this, Judge?
All right, it's been on record. Thank you all.
But Noel's short-lived temporary freedom was really short-lived. Within months, the sheriff made the mistake of underestimating the court's resolve. By March, law enforcement returned to his apartment again and, upon search, found hidden arms stockpile. Clear indication Noel did flout the terms and conditions of his release. The finding led to another trial appearance. Again, though, the judge had run out of his patience. Hesitant, the judge pointedly reminded everyone present that this was the last time he would be tolerating such nonsense, and indeed, everyone was going to be harder on him this time.
I told Mr. Noel, don't do anything stupid. Do not try to deceive me, defy me, not like the consequences. Today is that day. You are not the law. You don't interpret the law. You don't enforce the law. You're not above the law. I find that you are in contempt of this court. Take No. I'll find you guys in contempt of disrupting the proceedings, and you'll be there.
Although not uttered until now, the judge's words hung over the entire proceedings. Noel was not above the law. He was neither issued a license to interpret nor to enforce for himself alone to play the thing. And now, as a man once granted the greatest authority, he learns his truth in the most undignified of ways. The contempt that Noel had shown the legal process was matched equally by its response. The judge declared him in contempt of the court and had him taken into custody immediately. As Noel is led away to detention, the plot thickens in another direction as he becomes the protagonist of the whole thing. Ironically, the man who one time held the stage on the reality show 60 Days In, a series designed to expose the inner workings of law enforcement, now finds himself on the opposite side of the law. No secret was made of the poetic justice of this, as he told the world of the fall of Sheriff. Once hailed as champion of justice, now he is entangled in it. With Noel's immediate future being threatened by his contemptuous behavior, the judge considered what punishment this fallen sheriff deserved. Should he be given the maximum of 180 days for contempt, or should he be spared? The judge was perhaps reminded of the sheriff's previous affiliations with the very system that was going to finally convict him. So, he sentenced him to 60 days in jail, as appropriately fictionalized by the title of the show. It is a kind of symbolic punishment and a scathing reminder that no one is exempted, not even those who hold the keys to the system. But even as Noel was meted out this immediate punishment, his troubles were far from over. His defiance had thrown the door wide open to further scrutiny. The judge demanded that upon releasing him, an independent inquiry must be conducted so as to ensure that no other weapons remained concealed in his home. Noel's repeated claims of ignorance about the firearms found in his possession came ringing hollow in the courtroom. Everyone had heard it 100 times from other defendants, but when it was said this time by a former sheriff, it was especially damning.
Hear it.
Now, what is an appropriate sanction? The question is, I can sentence him up to 180 days without a trial. Or I can sentence him to a day. Or I can release him. You know what I think the answer is? 60 days in. That's what I think the answer is today. Now, Mr. Wild.
Sure.
Or Mr. Floyd, I apologize, Mr. Floyd, you're lead. Before he is released, I'll take your steps. I want an independent individual to scour that household to determine that there's no further weapon. I find that Mr. Earle's original argument that he was trying to make that sustain an officer of the law. Every time I go into court, I hear, I didn't know it was there. I didn't know it was there. I really didn't. You've heard that a million times. You've heard it a million times, and yet you still take them into custody, be my guest. Every officer in the world has heard, I didn't know it was there. It's my friend. I'm not buying it. It was your burden. It's your responsibility. And today, the court will enforce that. Take more.
As the hearing came to a close, there was no avoiding the seriousness of the situation. Jamie Noel was facing not only the weight of contempt, but the much bigger trial looming on the horizon. This 60-day sentence was but a precursor to the awaiting 31 felony charges. Here was the once powerful figure whose name commanded respect and authority, now on the brink of serving years in prison for his crimes, having reached the nadir of his fortunes. While the story of Noel reached its grim chapter, another case soon drew public attention. One involved Ronald Anthony Burgos of Isles, a former supervisor of the U.S. Border Patrol who was on trial for a crime so brutal it shocked the nation. His actions also reminded everyone that power, when abused, could lead to the darkest of outcomes. The incident happened close to the banks of the Rio Grande, not far from Father McNabeau Park, within the Laredo, Texas city limits, or more accurately, Webb County. Officer Cortez Jr., who was sent to the scene, described approaching a very gruesome crime scene where he first saw the body of an unidentified woman. She is lying barefoot, face down, and all around her are splatters of blood. The lacerations on her head and the massive loss of blood in her torso area seemed to tell of a very brutal attack. Cortez immediately secured the crime scene to prevent contamination and began canvassing the area.
That morning, more or less around 11:30 a.m., I received a call. A female down by Bristol and Riverbank Road, located in Mines Road, with lacerations to her head. While en route to that call, my dispatchers informed me that she was possibly deceased.
Okay. And did you proceed to that area?
Yes, sir. Upon arrival, the ambulance, the Digging Laredo paramedics, the ambulance was already parked outside. I parked and I walked down to the trail.
Okay. Did you come in contact with anybody?
Yes, while on my way down, two paramedics were on the way up, and I asked them more or less where is everybody. They said follow the dirt trail, and you'll see the body.
Did you come into contact with a deviation of the identity?
As he headed south, he highlighted bloodstains on the dirt path and escorted by U.S. Border Patrol, USBP Agent Dennison. The investigation of the crime was in its early stages as Agent Dennison was shocked by an even more gruesome discovery, another body, that this time was a child. The presence of the two lifeless victims heightened the intensity of the event. He described first how he came upon the woman's body. She was lying on the ground, her face downwards, barefooted. Bloodstains were in her clothes and all around. Cortez pointed out that much blood clotted around her upper and middle torso parts, hinting she must have borne grave injuries. Cortez took care not to disturb the dirt or grass around the scene, as evidence could have then been polluted.
Where DP units were stationed, 4 to 5 United States Border Patrol agents were located here, and a motionless, lifeless female body was about right here. She was facing eastbound, and upon leaving the police officer, secure the crime scene to bring evidence to prove anything out of the ordinary. As I began to canvass the crime scene, better word, I was walking around this grassy edge. There was one USBP agent, Agent Dennison, already ahead of me, coming south. I passed the female body. I did look at her. I observed she was barefooted. She was face down. Lots of blood. Can you hear me? Yeah, lots of blood around her upper middle torso on the dirt. And continuing my path southbound, I saw blood drops on the dirt. At this time, Agent Dennison said out loud, I found...
Having secured the scene, Cortez called out to Agent Dennison, but he was calling from further south and alerted him that another body had been discovered. This, unbeknownst to Cortez at the time, was going to be an even more sorrowful discovery.
In the situation,
What was your impression of what had happened?
any prudent person will see a lifeless, motionless body to come to the conclusion she was deceased.
But at that time, the opinion as to how she was deceased based on what you're seeing, what you're are you making an assessment?
No, she was brutally attacked.
You also testified that said that there was a body.
And that is correct.
What happens at that? Or what do you do?
At that point, she was ahead of me, southbound. When I heard him say, I found another body, I walked towards his direction to his location. He was no longer on the dirt path. He was in the brush. And when I arrived there at the brush with Agent Dennison, I observed a motionless little boy.
It is later determined that Dominic is a year old. Officer Dennison had discovered him in the brush, about a step off the dirt path. Cortez described the tragic scene as he stood over the child's body. The boy wore little brown booties and blue jeans through which blood was coming. The boy's freshly cut hair was always quite noticeable to Cortez. This time, though, it only made the view more sad.
Of course. Little brown booty, little brown boy booty, blue jeans that were covered in blood, freshly haircut, and what caught more of my attention was the way the body was positioned, he was placed. He wasn't thrown, he was placed. It's as if someone had placed it down.
Did you see any injuries to the baby?
Yes, lots of blood around the neck area, and that came down. I said again, blood on the blue jeans.
recognize this?
Yes, no, I didn't. Sure. Yes, sir.
Did you see any other injuries on the baby? How close were you to the baby?
Standing right over the body.
How many injuries did you observe on the baby at that time?
I only observed one.
What caught Cortez's attention was that the child seemed to have been laid gently on the ground. He stressed the fact that he looked as if someone had placed him on the ground after he pointed the beginning of the crime his way, indicating a chilling deliberateness in the crime. There was blood around the boy's neck area, although more bloodstains were visible on his jeans. The only wound he could identify was on the child's neck. Officer Cortez testified that the clothes later produced in court were the ones the boy had been wearing at the time he was discovered. The heavy weight of this realization visibly burdened him when speaking about the tragic scene and how the father of the child was calmly sitting at the crime scene without any visible display of emotion and shock, a detail noted by the investigators. Actually, he recalled the radio transmission at the crime scene in which Burros had been mentioned as the name of the suspect. This was not known to him at this point, but he did remember seeing that something caught Agent Dennison's attention when he heard the suspect's name mentioned. To his surprise, Dennison wasn't shocked by the hearing of the suspect's name, but somewhat surprised in an air of eerie familiarity. Cortez revealed that Dennison did not seem to be shocked or concerned by the news. This situation creates more suspicion because of the nature of the crime and the gruesome discovery of two bodies.
Agent Dennison was in front of you this whole
Yes,
time?
he was with me. Yes, sir.
And you were with him when the shoe was found?
Yes, sir.
What communication came over the radio that morning?
It was broadcasted. Possible suspect, Burgos. That was broadcasted over at my P unit, portable unit.
What was your reaction at the time? But when you heard Burgos, what did that mean? Did it mean anything to you at all?
No, sir.
Did Dennison?
Dennison was in close proximity where he could hear the broadcast on my radio.
You have your radio.
Yes, sir.
The name Burgos comes out.
Yes, sir.
It means nothing to you.
No, sir.
Do you see a physical change in Agent Dennison?
Yes, sir.
To you, what do you see this physical change?
He was in shock.
As the investigation continued, the authorities focused on Officer Dennison's behavior. In response to the question regarding Dennison's state of mind, Officer Cortez testified that the agent seemed very composed and unrevealingly calm, with no shock or remorse in his body language, given the gravity of the situation and the fact that a child and a woman had been brutally murdered. In this regard, Cortez stated that Dennison was not of one who had just stumbled upon such a ghastly crime scene. The uncomfortable silence led the detectives to investigate further if Dennison indeed knew Burros, or even worse, was an accomplice to the crime.
Hey,
And you saw Mr. Burgos there at the scene as well?
I saw many of them, yes. But sitting here, I recognize them, yes.
And he appeared to be in shock as well as Agent Dennison, correct?
No,
That was not your impression?
no, sir.
So you're saying that he appeared to be normal to you?
Yes, sir.
That's what it-
There appears to be very little in common with this parallel case and the ongoing story, but it is really quite important because it is related to a second police officer who is making an abuse of his office. On 11th May 2017, Fayette County Police Corporal Tyrone stopped a pickup truck for a technical check. To his surprise, the driver was State Senator Marty Harbin, a politician known for his advocacy of controversial religious freedom measures. The officer learned that Harbin was driving on an expired tag, and according to department policy, any vehicle whose tag has been expired for more than 30 days must be towed.
Our policy, over 30 days of its expiration, we have to tow the vehicle.
you sing it to me?
Yes, sir.
I'll call it. I won't call Eric Dial, but I'll call the rest of them. But I pay my bill. This will not go over well. I can tell you can talk to everybody at the department.
But when Harbin was told his truck was to be towed, things began to escalate. He tried to go by his political muscle by promising to change the law, and wanted the officer to understand that he isn't pleased with the situation. Even if Harbin begged and was of political standing, the officer insisted that he follow the law and had the truck towed away. This is how frustrated some officials are, who think they're above the rules and regulations set for normal citizens.
Influence.
Because I'm going to take this, and I'm going to the state, we're going to change the law. You're not the only one that's happened. Yeah, I mean, but I'm just saying, it's not like we're picking on you. The law's wrong in that respect. Okay. And I'm not mad at you. That's what I mean. We can't change the law. Well, I can't.
Outraged at what he considered a draconian punishment for a minor offense, Harbin then did go out and propose a bill in the state legislature to prohibit vehicles from being impounded due to expired tags. His experience with the officer that day seemed to sear into his conscience and spur him to lobby for legal reforms as a way to mitigate the gravity of offenses such as expired tag violations. But the case went on to well demonstrate how an interplay exists between law enforcement officials and officials in public life, who believe that the same laws they may have helped enact do not apply to them.
It was moving fast.
Okay. Was there any movement into other lanes?
Yes, sir.
Okay. Tell me about that.
The vehicle moved from the fast lane to the center lane at one point in time. And then from the center lane to the curb lane and then back to the fast lane. And then eventually exited the freeway, sir.
Okay. So when you were following the vehicle, it moved from the fast lane to the center lane to the curb lane, back to the center lane, back to the slow lane. Did I get that right?
Something like that, yes, sir.
Okay.
That's close.
Okay, so the vehicle changed lanes.
So the vehicle did change lanes.
Okay. And then the vehicle exited the freeway.
That is correct.
Okay. All right. Do you remember speaking with me during an interview a little while back?
Yes, sir, I did.
Okay. And you gave me honest answers during that interview?
To the best of my recollection, yes, sir.
Okay. Do you remember me asking you about the vehicle's movement during that interview?
No, sir, I do. I remember you asking the question, but I don't remember the exact particulars, sir.
The courtroom drama within the Harbin case was not over, and another dramatic moment erupted as the officer who had detained Harbin took the stand. He was questioned by a lawyer about the veracity of his testifying. The policeman first testified that the car of Harbin had made no changes in lane during the pursuit. But during the intense cross-examination, the story changed.
Do you recall me asking, when you were following the vehicle, did it stay in the same lane the whole time?
I know you've asked numerous questions. That may have been one, yes, sir.
Okay. Do you recall your response?
No, sir, I do not.
Okay. Permission of the court, Your Honor, I would like to play a portion of my interview with Sergeant Police where I asked him whether the vehicle, when he was following it, did it stay the same lane the whole time?
No.
Just going backwards a little bit. When you were following the pickup truck, did it stay in the same lane the whole time? Okay.
When we got closer to that.
Did you hear that, Sergeant?
Yes, sir, I did.
Okay. So when I asked you, did the pickup truck stay in the same lane the whole time, your answer was yes, it did.
That is correct.
An attorney revealed some discrepancies in testimony presented by the officer, and he indeed confessed on tape that in fact several times his vehicle changed lanes before leaving the freeway.
And just before I played that, when I was asking you about whether the pickup truck stayed in the same lane while you were following it, you told me that it moved from the fast lane to the middle lane, to the slow lane, to the middle lane, to the slow lane. Is that correct?
That is correct, sir.
So, which was it?
the fast lane the whole time. And at some point in time, as I just mentioned to you, he did move from lane to lane, sir.
Okay. So you don't find anything inconsistent with what you told me here in court and what we talked about?
I could see where he would see that as an inconsistency, yes, sir.
The lawyer succeeded in pointing out contradictions which all lead to linking credibility to the officer, who was left speechless after this video evidence became a highlight of the issue at hand, explaining why law enforcement officials must be held accountable for misrepresenting facts when sworn in. These stories tell the very different range of problems that exist within law enforcement, from violent crimes such as the Laredo double homicide that terrorized an entire city to police officers misusing their authority and/or not even doing their jobs. While justice was served in so many of these stories, they still underscore the urgent call to reform, transparency, and accountability within law enforcement agencies. It requires the people entrusted with law enforcement to lead by the greatest virtues of integrity and forces consequences when they fail.